Hello and welcome to the latest edition of the Data Privacy Party installment. Let's get started. Well, hey everybody, welcome to the Data Privacy Party podcast installment, whatever you'd like to call it. I'm your host, Hunter Winfield, and today do something a little bit different than what we've done in the past. So I know that we've been kind of slowly chipping away at a kind of learning series around the CIPT certification and the introduction to privacy technology textbook, but today we're going to talk about something maybe slightly overdue. There's already been a lot of content put out there for it at this point, but the newly enacted EU-US Data Privacy Framework. So, I know we're going to go in a little background first before I get into what it kind of says high level for some of y'all with some guidance and resources. But this is something that allows data transfers from the US and European Union member states to happen basically in kind of a general sense. So one organization operating in America transferring data to the EU, same goes for the other way around, needs to have certain protection measures in place in order for that transfer to actually happen. It's not something that can just be done without much rhyme or reason. There's different laws that pertain to the EU, such as GDPR. There's different laws that pertain to the US, such as a lot of state privacy laws, and then various federal ones, such as the Health Information Accountability and Portability, Health Information Portability and Accountability Act. Sorry, y'all. Gramm-Leach-Bliley, FERPA, and then a number of others that are soon to be kind of rolled out in the coming years. So essentially what this does is to kind of keep up with what's going on and also plan ahead. So back on July 10th, so we're a little over a month in at this point, the framework was adopted by the European Commission with responsibility for looking into those things. They adopted the adequacy decision, determining that what they found in the proposed EU-US DPF and the changes that have been made since the privacy shields are adequate to address all the privacy needs outlined within GDPR for the European citizens. And so this is kind of completes the commitment. I don't know if any of y'all were aware of this, but back in October 2022, President Biden issued an executive order essentially committing to working with the European Commission and various other bodies to develop the data privacy framework that's going to be in place to kind of protect a lot of those transfers. So before we go into it, I want to take a look back and kind of, explain a little bit as best I can about the journey that, these transfer mechanisms have gone through over the last several, decade or so. And we got to take it further back. We can start with the Organization for Economic Cooperation and Development, the OECD. They kind of created the first privacy principles back in the 80s. So there were 8 of them. And since then, other various organizations have kind of adopted and modified as needed. So the first sort of widely used, recognized transfer mechanism between the EU and the US was called the International Safe Harbor Rule. So this was brought about kind of around 2000s or so. And this encompassed 7 key principles. Now, keep in mind, these are going to be principles that they don't deviate from. They just kind of add a little bit of different, maybe language as well as protections, kind of assessing the protection measures afforded to European citizens in the United States. And so these 7 principles, if you're writing stuff down, I'll put them in the show notes as well, are going to be, and we'll talk about them here soon. Notice, choice, onward transfer, security, data integrity, access, and enforcement. We've kind of talked a little about these in some past episodes as well, so please feel free to refer back to those to kind of get some more detail on some of those things. But yeah, the safe harbor rule came into play And that essentially was facilitating a lot of those transfer mechanisms between EU organizations, US organizations, and the protection of personal information. Well, a lot of you probably remember Edward Snowden. The name should sound familiar to some capacity, especially those that work in our space. When the revelations that the US government was surveying its citizens and being too intrusive in that surveillance practice, Snowden blew the whistle. And when that happened, there's a privacy lawyer, privacy advocate named Maximilian Schrems, who has been kind of the main voice, especially in the European Union, for challenging a lot of these decisions that have come through. So back in 2015, he actually, based on the Snowden revelations, challenged Facebook Ireland and requested his data transfer be suspended. And this ruling, since we found out, okay, the US is not doing all that much to protect our data, they're not doing all that much to protect any transfers, they have too much access to our data. The Data Protection Commission, or rather the CJEU, decided that they were going to invalidate the safe harbor rule. So 2015, the safe harbor rule was invalidated, thus leading to the creation a few years later of the US EU Privacy Shield. So that was the next in a, at the time brief, it's starting to get a little bit longer sort of framework used to facilitate and protect the transfers of data between the US and EU. So this kind of came to light, or not came to light, I guess. Discussions started happening around 2016, beginning of 2016, between the European Union and the US government to finally reach an agreement around their next adequacy decision. So in April of 2016, an opinion was delivered from the Article 29 Data Protection Working Party. They're pretty involved and a great resource for anything related to data protection. I encourage y'all to check them out. April 13, 2016, provided their sort of opinion on the new and improved Privacy Shield, which offered major improvements compared to Safe Harbor. So as we kind of continue down the line, this was adopted, still sticking to those same 7 principles, but just adding a little bit more meat to each one of them and some more requirements. So this Privacy Shield lasted for a decent amount of time. I actually am not off the top of my head remember exactly how long this ended up going into effect, but we can kind of expect around, I don't know, 4 or 5 years, because we know in 2020 it actually became invalidated. So our privacy advocate Max Schrems once again challenged the decision, which is known as Schrems 2, the safe harbor challenge known as Schrems 1. Schrems 2 was July 16th, or not exactly on this date, but this date, July 16, 2020, is when the Court of Justice of the European Union issued the decision in, once again, between Schrems and Facebook Ireland, that invalidated the US Privacy Shield framework. So to knock down, back to the drawing board once again for the US and the EU. Hopefully the third time's the charm, like we usually like to say. But now that one didn't go through and Privacy Shield was struck down, we needed a new one once again. So earlier, back in July of 2023, July 10th to be exact, the EU-US privacy framework, data privacy framework, was enacted. The decision by the European Commission, they issued the adequacy decision for it. So This impacts a number of industries across the globe. Decision requires companies and regulators to assess the protections afforded to personal data transferred outside the EU on a case-by-case basis. This was back on the Privacy Shield front. As we fast forward into the data privacy framework, this is a lot more looking into laws and what's going on in that country, matching it up to GDPR. Is there a gap? What's the gap? How material is the gap? And so on. So I'll add into the show notes a lot of the stuff that you guys are probably going to want to be interested in, some links, some of that content. But what I really want to get into, we're going to talk about the 7 sort of areas between the EU-US data privacy framework. So the 7 principles, I mentioned them earlier, and I just am going to cover each one of them fairly high level. I'm not going to go into details. I'll add links in that y'all can go to in order to find a little bit more information on some of those, on some of these principles. So, you know, third time's a charm. We'll see. Schrems 3, I'm sure, is on the horizon. It'll challenge it once again, but if it passes through that, you can rest assured that we probably have a good one in place this time around. So the first principle is notice. So we've talked about this before. How does an organization inform its user base of what it's doing, how it's doing it? What's that medium that it's providing to the individuals? Is the notice on the website? Is the notice sent via mail? Is it sent electronic mail? How is that done? Is there a privacy policy? What does the privacy policy say? So a lot of the requirements, if you will, inside of this specific principle is that it just doing, like we just said, inform individuals of the organization's participation in the DPF. So that's something too we'll talk about here in a bit. You actually have to be a participating member of the DPF in order to have kind of that certification. Once you have that, then organizations know, okay, they're adhering to all these principles. But this notice has to show what types of data are collected, what's the purpose for that collection, what is the contact information of the controller, like who can you and I as individuals, data subjects reach out to, what third parties are those data sets sent to, and then what individual rights and are you and I afforded? You know, what does GDPR say about it? What does the state and local laws say about it? What disclosure practices does the organization have to inform us of what's going on with our information? So, which is a requirement that they need to, via GDPR and other state privacy laws, that they need to be able to, especially upon request by the individual and the data subject, to tell them what is going on with your data, be completely transparent about it. The next principle, principle 2, if you're numbering them down, is choice. So this is kind of talked about it in some previous episodes, but 2 of the main things around this principle is that the organization has to offer the option for individuals to opt out. This would be for purposes beyond the original scope, as well as just what's currently going on. So at any point, they need to give the individuals the opportunity to cease processing of their data. If the organization is going to begin using that information to make, different decisions, different processing, maybe they originally collected my, if I registered for a magazine company, physical magazine to be delivered to my home, I would ask, just give them maybe my name and physical address, obviously zip code, a few other things. They would need to actually get the magazine to me. But then if they wanted to start processing that data, not just to deliver me a magazine, but to also, look into income level or something that's outside of just delivering me the magazine, I would need to be given notice that this is happening, and then have me give me the option to opt out of that processing. Another thing too is providing choice. is, and this is kind of a little bit of an cop out, if you will, in some capacity, but providing choice is unnecessary when data is provided to a third party acting as an agent of the organization. Organization collects my data, they send it off to another organization, and that organization does processing on behalf of the organization that collected my information. Now, the third party does need to have adequate security measures in place. However, I can't opt out if them sending that information to the third party is a part of that original purpose for collection and processing. Hope that kind of makes sense. A bit of a roundabout way of circling around it. Third principle is accountability for onward transfers. So this a little bit touches on what we just talked about, but is not necessarily the same thing, or else it would be factored into the principle too. This is for transfers are done for specific purposes and verify the transferring agent has adequate protections in place. I mean, it harpens back to what we talked about where they provide to a third party. So maybe I can't opt out of that, but that third party still has to have adequate security measures in place if they're going to transfer my data to someone else to process it. Chances are the company makes a copy of my data, sends the copy over, so they still have the raw information of it, rather than just sending package A to pack 2 from company A to company B. Company B sends package X back. There's going to be storage, copies of data, and all that kind of stuff. Also, a contract between an org and third party must include language to ensure the same data protections at the organization are afforded to the data at the third party. So like I just said, security measures in line, the minimum requirements of the organization must be met by the third party. Principle 4 is security. So, and a lot of these you'll start to hear them. It may kind of sound like they all kind of mesh together. That's very much the intention. If organizations are doing, a few of these very well, chances are they're doing the others very well also. But with security, organizations must take reasonable and appropriate measures to protect data from loss, misuse, and unauthorized access, disclosure, alteration, and destruction. Organizations must also take into account the risks involved in processing and the nature of the personal data. So various security frameworks are out there, ISO, NIST, and several others that can kind of help organizations make decisions around the protection of that data. There's specific, the NIST privacy framework is one that's very specific to personal data and the protection of that and what's in place, both from a security standpoint, governance standpoint, and a technical, administrative, and physical standpoints, all kind of wrapped into one framework. Principle 5 is data integrity and purpose limitation. So personal information must be limited to the information that is relevant for the purposes of processing. We kind of mentioned this earlier with providing notice and choice for those individuals. Data cannot be processed in a way that is inconsistent with the original purpose for that collection. Individual data should only be identifiable as long as it serves a purpose for processing. Companies are allowed to keep and retain information they collected as long as they de-identify that information, and to the point where a reasonable individual wouldn't be able to re-identify. For instance, company they collect my first, last name, and zip code. If they just delete my last name, there's probably a pretty difficult chance for them to identify me just based on name and zip code alone. If you have a less common first name, they probably want to delete first and last name. If you have a more common last name, maybe just the first name, you can leave your last name and zip code, or just delete the zip code if your name is fairly common. John Doe at 1, 2, 3, 4, 5. Probably going to be pretty difficult if you just delete Doe. So John at 1, 2, 3, 4, 5. There might be quite a few of those. You wouldn't be able to identify them. If you delete just the zip code, John Doe, several of those, so it'd be kind of difficult to identify at that point too. But another last little bit on this one is that processing can go beyond the purposes if it is done for archiving in the public interest, journalism, literature, art, scientific or historical research, statistical analysis. This is baked into GDPR. I can't remember the article off the top of my head, but there's various areas in which you can process beyond what those purposes are. Now, chances are a lot of private companies are not doing this for some of these different things. However, a university institute needed to do some scientific research for a thesis or grant that they're looking into to see what they can find out about something, and so they need data from a company. They can take that information and all of the necessary attributes should be kept in there that they need in order to perform that analysis of what they're studying. Principle 6 is access. This one I know we've talked about in the past. And it's just generally allows individuals to access personal data the org collected. Talked a little bit about this actually earlier back in the choice principle and notice, but they also need to allow individuals to correct, amend, or delete that information where it is inaccurate. Allowing individuals access to their data, they can feel in control and can be in control of the decisions that are made with that information. The last principle, this is around resource enforcement and liability. So there's some mechanism. This is actually the longest one of each of the 7, and just how the it's laid out. But mechanisms must include, 3 things. So one is a readily available and independent resource mechanism where each individual's complaints and disputes are investigated. And that's kind of in this accountability, enforcement, liability section. So follow-up procedures to verify the org's assertions about its practices are true and privacy practices are implemented, and obligations to remedy problems and consequences for non-compliance. So first one being there needs to be an independent resource to assess what's happening. There needs to be follow-up procedures to verify the organization's own assertions about its practices are true. You can kind of, I don't want to leave the 3 out before I go to my next thought. And then obligations to remedy those problems. If anyone has worked within audit jobs for Sarbanes-Oxley related clients, you'll know 404A requires management to attest to their controls. 404B requires an external auditor to issue an opinion on a lot of the controls and finances of the organization. So this very much follows the same kind of way. So the organization having something in place that can kind of attest to what it's doing. Individuals can issue complaints, disputes, and they can get investigated. It's kind of an entity that's independent, much like internal audit being independent of the organization. And then having some follow-up procedures in place that verify what the org is saying about itself, kind of an external audit. And then just the follow-up procedures, the obligations to remedy any sort of instance of non-compliance. The responses from the organization to individuals and other inquiries must be prompt. They have an obligation to arbitrate claims from individuals when they come through. For any onward transfers, a participating org is responsible for the data it receives and transfers to a third party acting as an agent on behalf. We talked a little about this in onward transfers earlier. If they need to send it to a third party to perform processing, they are still responsible for the data and the security of that data. Liability doesn't leave the organization with the data that gets transferred to the third party. They still have a liability and a responsibility to the customer whose data they collected to make sure that data remains protected. And lastly, in the event of a court order, the organization shall comply and make evidence available to the court of U.S. statutory body to the extent which they with confidentiality requirements. So essentially, when a court order comes through, they have to comply with that order, fight it, or be obligated to take whatever action is necessary, but you can't just ignore a court order that comes in. Usually doesn't end very well for the entity, and it kind of helps. The United States has some some action kind of in there. So the key requirements, we just named off quite a few. Those can be found at the Data Privacy Framework website. I'll link everything in the show notes for y'all, but dataprivacyframework.gov is the website they set up to just kind of help organizations navigate this new framework and how they can join. So there's two kind of things to note. So obviously most organizations are going to have to newly certify right off the bat. So you can either self-certify if you have your own kind of, whether it's audit department or some sort of compliance department where they can perform the certification, or obviously a consulting firm that specializes in these kind of things can do the certification for you, obviously for a fee, depending on what they charge. But that is kind of the process to newly certify. I'll add the link into the show notes. And then after that, it requires an annual recertification. And so that one actually is a different form. I'll also paste into that with kind of some instructions on how to do that. But annual recertification, like I said, for all orgs, there's a 7-step overview on the website. You can kind of follow over to that. All right, we'll jump in real quick. Not to get away from the backbone of the show, I still want to go through our party poopers. There's 2 of them I really wanted to call out. One of them, since we haven't done a show in a while, this is actually my last one. The last episode came out before the DPF, I believe, was even decided upon, so we couldn't really talk much about that other than just speculate what was going to happen. But since then, the first one around mid-July, it was made public, if you will. There might have been some other folks that knew about it prior, but the U.S. military sending emails to Mali unintentionally. Hopefully y'all heard about this, but essentially a Dutch contractor managing Mali's .ml domain reported that millions of U.S. military emails were misdirected to Mali through typos for over a decade, according to the Dutch contractor. So the military email domain is .mil, .gov, .com, .net, whatever. It was mistyped as ML. And anyone that knows about a cache storage, especially with emails, knows that once you type it in one time, send that thing off, typically you'll just type in real quick, it'll default to it, you'll click enter, send it along. So lots of folks forgetting to put that I between the M and the L, just had cached emails saved that were misdirected to the Mali domain. Chances are it's probably pretty unlikely that if someone was sending Hunter H. Winfield at usgov.mil, highly unlikely that existed as a .ml domain. However, there's still several that were sent along, some of which contain some secret information that probably shouldn't have been out there just sitting on a web server, an exchange server, or whatever kind of email server they had. Some emails contained, like I said, sensitive information like passwords, medical information. Johannes Zerbeyer was the individual that alerted U.S. officials about the issue approximately 10 years ago. Apparently not much was done. So, and like I said, the .mil is the domain for the U.S. Department of Defense. And then the .ml is the domain for Mali. So I'll drop links to the story so y'all can read more about just that funny bloop that kind of happened. And there's probably instances in which someone didn't get the information they were requesting because they sent it to the wrong individual, or they sent it to a server that quite frankly doesn't process. Typically when something doesn't go through or the email doesn't exist, they'll get back a message saying it. So doesn't mean it doesn't get stored on the server, but yeah, 10 plus years of that mistake going on. Next one, briefly talk about Experian Consumer Services. So the FTC issued a $650,000 fine because Experian was spamming its consumers with unsolicited emails after they registered for an account. Consumers weren't offered a way to opt out of these spam emails, so they are not being fined because they continuously spammed people. Unfortunately, it seems like there's not enough justice in this world for that, but they're being fined because they did not offer a way to opt out of those spam emails. And then they multiplied it by however many customers it was, got them around $650,000 fine. And that is how things go and how the cookie crumbles. Experian should be fine paying that fine, but just a funny thing for them. I'm sure if you're an Experian customer, you probably have felt this pain, especially not being offered a way to opt out of spam emails. Kind of ruined email for everybody with all the spam that you get, but that's kind of unfortunately the world we live in right now, especially if you use email. So hopefully you're not an Experian customer and haven't had to deal with the spam emails. Well, that's all I've got for y'all today. Thanks for tuning in. I'm going to try to start making these a little bit shorter. I know that they've been approximately an hour in the past, and that's kind of tough to listen to. So if you've held on this long, thanks. I appreciate it. And I look forward to being able to share more content with y'all in some of this shorter format going forward. So until then, thanks for tuning in. I will talk to you guys later. Thanks for listening to the latest edition of the Data Privacy Party install. Hope you learned something new and can better protect your information. Like us on YouTube, Apple Podcasts, and Spotify, and subscribe to hear more great content.